Good morning, students. Today we would be revising state nationality, which is a very important topic under public international law. Now, why it is an important topic? Because we have talked about state sovereignty, and we know that sovereignty is the basis of all the international relationship. So, when we talk about sovereign state and individual, so there should be a link between this individual and sovereign state. What is that link? So, that link is established by nationality, that is state nationality. Now, state nationality has been recognized in a series of international legal instruments, be it Universal Declaration of Human Rights, International Convention, Civil and Elimination of all form of racial discrimination, International Covenant on Civil and Political Rights, and so on and so forth. So, when we talk about UDHR under Article 15 of UDHR, it has clearly provided that no one should be arbitrarily deprived of his or her nationality. So, nationality is a very important concept, and when we come to the definition of nationality, there are two definitions which is very important. One is given by Charles Fenwick, and the other one is given by Stark. So, when we study these two definitions, it is talking about very important tenets. That is, Charles Fenwick said that it is a bond between that unite an individual to a state and gives his membership in that particular state. Also, a person can claim protection and subject himself to certain obligation of that state. This is what was said by Charles Fenwick, which we have already discussed in detail in class. Now, Stark has defined nationality as a legal status of membership of the collectivity of individual whose act, decision, and policy are vouchsafed to the legal concept of the state representing those individuals. So here Stark is talking about that all the act, all the everything that is done by the individual are vouchsafed by the legal concept of the state. That is, state is keeping an eye on all of it, and if he doesn't fulfill his obligation within the state, then he would be liable to be punished. So a nationality determines the rights and obligation which a person has within a state. Now, if we talk about importance of nationality, I've already told you that with nationality, you have certain rights and obligation in that particular state. For example, you may have right to have a valid passport. You may have right to vote. So there are certain rights which you get because you're a national of a particular sovereign state. So with nationality comes certain rights. Yes, with nationality also comes certain obligation. For example, there's certain manner which you have to conduct yourself while being in the country. So all of it, your rights and obligation, everything are vouchsafed by the state, or I would rather say law of the state. Now, Liechtenstein versus Guatemala is a very important case establishing the importance of nationality. So here the main point was that Nottenberg, he was born in Hamburg and held German nationality by birth. Okay. Now, he went to Guatemala in 1905, took up residence there, and made that country the headquarters of his business. He had some business connection with Germany also. So, born in Hamburg, held German nationality. Later on, moved to Guatemala, took up residence there, set up the headquarters of his business. He also has business connection with Germany still. Now, what happened was he made few visits to his brother in Liechtenstein, and later on applied for being admitted as a national of Liechtenstein. Liechtenstein government had issued the granted, and a passport was issued to him, and the 3-year residence requirement that was there in Liechtenstein government for giving nationality was waived off. Nottenberg returned to Guatemala, and when Guatemala later declared a war on Germany, he was interned and his property was confiscated. So in 1951, the government of Liechtenstein instituted proceeding before the International Court of Justice, in which it claimed restitution and compensation on the ground that the government of Guatemala had acted towards the person and property of Mr. Nottenberg, who is a citizen of Liechtenstein, in manner which is contrary to international law. Now, in this case, what happened was the court talked about having a real and a genuine and effective nationality. Now, if you see, Nottenberg was born in Germany, he was having German nationality, then he moved to Guatemala, where he was conducting his business. So he had genuine link with Guatemala. Also, he has genuine link with Germany. Liechtenstein, he visited, made few visited to meet his brother. It is not establishing a genuine connection or an effective, connection between the sovereign and the individuals. Therefore, he would not be regarded as a national of Liechtenstein. Why? Because there is no genuine link. So the court in this case said that nationality is a legal bond having as its a basis a social a fact of attachment, a genuine connection of existence, interest, and sentiments, together with the existence of reciprocal rights and duties. We also will be talking about dual nationality. Dual nationality means when a individual has connection or formal relationship with two separate sovereign. So this type of nationality is prohibited in India. We do not promote dual nationality. Also, this might occur, for example, for person parents are national of separate country, and mother's country claim all offsprings of the mother as their own national, but father's country claim all offsprings of the father's nationality. So this would, in this case, there would be dual nationality. For example, when we talk about Mrs. Sonia Gandhi has obtained the nationality of India, but her nationality of Italy is not terminated. Why? Because in Italy there is a concept that once a national, always a national. So Sonia Gandhi also has, or Mrs. Gandhi also has dual nationality. Now, what is nationality and citizenship? Is there a difference between the two, or they are same? So many a time nationality and citizenship, they are often, considered to be synonymous, but there is a small difference between the two. And that is that nationality has reference to the jural relationship which may arise from consideration under international law. On the other hand, citizenship has reference to the jural relationship under municipal law. That is, nationality determines the civil right of a person, natural or artificial, particularly with reference to international law. Whereas citizenship is, connected with civil rights under the municipal law. So hence, all citizens are national of a particular state, but all nationals are not citizen of that state. So, in other words, to put it, more aptly, citizens are those persons who have full political right as distinguished from national, who may enjoy full political and are still domiciled in that country. So in a small or in a easy way to tell you, nationality is what you would refer at international law, the jural relationship between individual and sovereign at international level, and at municipal level it is citizenship. Now there are different modes of acquiring nationality, and how can you acquire them? So the first mode is by birth, and this is that nationality is conferred to a person by many states on the basis of birth. All those who take birth within the territorial limit of a state acquires the nationality of that state. Now this principle is also known as jus soli, and section 3 of Indian Citizenship Act 1955 has provided nationality on basis of birth. Second is naturalization. So a person may, require nationality at the birth. However, his nationality may later on change. So when a nationality of a person changes subsequently and he acquires the nationality of some other state, the process of acquisition is known as naturalization. And a person may acquire nationality through naturalization in different ways. For example, through marriage. Example, and your wife assuming her husband's nationality, or legitimation, option, acquisition of domicile, and so on and so forth. Section 6 of Indian Citizenship Act 1955 provides that a person may acquire citizenship by naturalization upon fulfillment of certain conditions. So by birth is clear, by naturalization is clear. Then we come to resumption. So sometime a person may lose his nationality because of certain reason. Subsequently, he may recover his original nationality after fulfilling certain condition. So when he again resumes its nationality after fulfilling that condition, that would be regarded as nationality by resumption. And section 20 of Citizenship Rule 1956 provides for a procedure for restoration of nationality. Then next we would be talking about a subjugation. Now, Section 7 of Indian Citizenship Act lays down that if any territory becomes part of India, those persons from such territory shall automatically become citizen of India. So, any territory that is become part of India, all the person residing there would automatically become citizen of India. That is what it said in Section 7 of Indian Citizenship Act 1955. Then next is session. So, what is session? Session when a part of a territory is ceded to an other state, all national of the former requires the nationality of the later state. So, for example, the part of a country is ceded to another state, or now has become part of another state. So, all the people would acquire the nationality of the new state. Then next we would be talking about is option. When a state is proportioned into two or more states, the national of the former state have option to become the national of any of the successor state. So if the country is divided into two parts, then all the national will have right to be part of the any of the two successors. And the last mode of acquisition of nationality is by registration. The process of registration may be different from one state to another depending upon the law of that state. It takes place when a person becomes the subject of a state to which he was before an alien. So these are all the modes of acquisition: by birth, by naturalization, by resumption, by subjugation, by cession, by option, and by registration. Now, flipping the coin, when we'll talk about the modes of loss of nationality. Now, what are the different modes of loss of nationality? And according to Oppenheim, there are 5 modes of losing nationality, and they are as follows. For example, release. And so, some state like Germany, it provides that citizen may lose the nationality by release. So, in the loss of nationality by release, it is necessary to submit an application for the same, and if the application is accepted, the person concerned is released from the nationality of the state concerned. Then next is by deprivation. Certain states have framed some municipal law, the breach of which may result in deprivation of their nationality. So deprivation is that state has deprived a person from nationality. Release is that a person has submitted an application to be released from the nationality. Then next we would be talking about is termination, or when the person is terminated from the territory. That is, he is forcefully terminated from the territory. Although deprivation and termination are one and the same thing, they are always used interchangeably, because in deprivation also state is depriving a nationality, and in termination also the state is forcefully terminating it. So they are one and the same thing. Then we talk about renunciation. In renunciation, the need for renunciation arises when a person acquires the nationality of more than one state. So in such a condition, he has to make a choice as to which country he will remain national. So this is renunciation. So finally he has to say, he has to renounce the nationality of one state. In case of double nationality of children, the municipal law of certain state like Great Britain give them right on coming of age to declare whether they wish to cease to be a citizen of one state or not. So that is a different situation with respect of minor. Otherwise, if you are a formal relationship with two or more country, you have to renounce and be a member of one country. Then is substitution. Some state provide for substitution of nationality. According to this principle, a person may get nationality of a state in place of the nationality of another state. This is called nationality by substitution, where he loses nationality of state and acquires the nationality of an other state. So in certain state, law provides that if national of that state without seeking permission of the government obtains employment in another state, he may be deprived of his nationality. Now, before we end, there is one more mode of loss of nationality, that is by expiration. So, in certain state, on account of legislative, legislation, rules and regulation, citizenship expires due to long stay abroad. So, if you're, then if you're staying in abroad for a long time, then your, citizenship may expire on account of legislation citizenship. So this was all about nationality, student, acquisition, the loss of nationality, dual nationality, citizenship and nationality. Then a very important case, that is Liechtenstein versus Guatemala. Then the two definition. Also, we talked about Charles Fenwick and Stark. Then we also talked about importance of nationality. So still, if you have any doubt with respect to this topic, please feel free to contact me either through mail or WhatsApp group. Thank you so much.